white book, it's called the white book. We have the family procedure rules, which is in the red book for family courts. And we also have commercial rules, company law rules, and so forth. So that is where we are. You can see the structure of the senior courts, the lowest courts being the magistrates and county courts, which are the workhorses of what I do, what most of my colleagues do. In the past, when I was first brought to the bar, it was a very different bar and a very different structure from what we have today, because the county courts and the High Court were totally separate. The county court had its own rules called the Green Book, and the High Court had the White Book in a different form. But what we've done is we've merged everything together. A man called Lord Wolfe, Harry Wolfe, he's the one who produced the new civil procedure rules that became statutory based by the Civil Procedure Act, and it's put everything on a statutory footing. Time. What I'm going to do is take my watch off. Because time management is very important actually in a lecture or mediation, or anything I do. Mediation is particularly important because I always have to get the balance right. And believe it or not, in courts today, although you think we have as much time as we want, we don't actually. We are very, very heavily guillotined on how much time we can have to deal with a case. Now, you will appreciate that if I'm dealing with a children matter involving warring parents, I need as much time as I can, because one of the worst things is to get them off the ceiling. They hate each other, they hate everybody, and the children are going to suffer. And our job is to make sure under Section 1 of the Children Act that we give, we would consider the interests of the children as paramount. Now, I say that because most of what we do today is statute-based. That means that those old dears down in the House of Commons, the House of Parliament, make decisions, and they call bills, and then they go out to Parliament. The biggest problem is a lot of them haven't got a clue about what they're really doing, because they've got elected on a particular political ticket. They are enacting legislation. And with great respect to a lot of them, they don't know what they're doing. The select committees look at the detail of the bill before it becomes an act of Parliament, and that's when the real work is done. But there's a lot of horse trading that goes on, a lot of prejudice, one side or the other, in the main political parties, and we have the Liberal Democrats and the SNP, Scottish National Party, as the two other minor parties of any consequence. But the difficulty is that the legislation which is actually passed by the two Houses of Parliament, the House of Commons and the House of Lords, then given their all assent by the Queen automatically. The difficulty is that some of the legislation that's produced isn't very good. That means that when there's an issue about what the wording of the section of an Act of Parliament means, it goes to the courts, and the courts then interpret. They have rules of interpretation, and they interpret what we think the intention of Parliament was. Because in our system, the common law system, statute law is the law that is the most important. It binds everything else. The common law, which is judge-made law, which is decisions, which I'll come on to in a minute, that particular area is subservient to an Act of Parliament. Because if, for instance, and we've had examples, a judge or judges in the higher courts, the Supreme Court mainly, but sometimes the Court of Appeal, if they make a decision that Parliament doesn't like, Parliament can intervene and change it. Harold Wilson did it. There are threats. David Blunkett, who was Home Secretary, threatened a number of changes when the courts made a decision which the governing party that they didn't like. It's very rare, actually, that happens. But we have, in recent times with Brexit, and I'll talk about Brexit if you want later, we have, of course, had this tremendous polarisation within our community. It's split communities. It's been terrible. It's split communities almost in the same way that the Civil War in the 17th century did. It's as serious as that. And this is the most problematic issue that we've had since World War II. So you can see it's a problem which isn't going away, and it has caused the departure of Mrs. May, and we will have lots of problems flowing on from that. Because there's something I haven't included in this slide, because above the Supreme Court of the United Kingdom is another court. But it's not in this country. It's in Europe, because we're members of the European Union. It's called the Court of Justice of the European Union. That's what it's now called. It was called the European Court of Justice. It's now called the Court of Justice of the European Union, because it changed the name. Now, the issue about Brexit really goes to the heart of in one area, of one big point, which is a sticking point for politicians, and that is the constitution of this country. Because people say, why should we have some foreigners in France or Germany telling us what to do with our laws here? Because appeals from the Supreme Court can go to the European Court of Justice, or the Court of Justice of the European Union, as it is now known, which is not to be confused with another court, which is the European Court of Human Rights, which is a totally different court. There's a lot of confusion about it. It's a totally different court, and nothing to do with, basically, with Brexit. Point is that with Brexit, if it does go ahead, and we leave on the 31st of October 2019, which is what looks to be the case, it means that the Court of Justice of the European Union will no longer be the final court, and our court, Supreme Court, will be the final court. Whether that happens or not is another matter, because one of the problems we've got, and I mentioned about politics, I mentioned about the way statutes are created, we've got, in many of our statutes, directives which have come from the European Union. They come down from the European Union. We are expected to implement those directives in our national laws. Now, dear old Margaret Thatcher, who I had a lot of time for, was quite clear that she was not going to implement some laws because she felt that they were impinging on our sovereignty. And I agree with that. Didn't have a problem with that. So she didn't bother implementing certain things. Mainly, I hasten to add, in commercial and company law matters. Now, on day one of the Blair government in 1997, he changed everything. He said, no, we're going to, en bloc, we're going to actually put all of those into English law. Of course, we then had, in addition to that, the creation of the Human Rights Act, 1998, which came into force in 2000. That in itself caused a tremendous amount of trouble because, again, Margaret Thatcher and John Major had been wholly opposed to the implementation of a statute-based set of rights called the Human Rights Act, enshrined in law, because that meant that virtually every aspect of the work done in all these courts is affected by the Human Rights Act. I was one of the people who didn't agree with what was going on, and we were shushed and told, you do as you're told, because the Labour Party had a 100-seat majority in the Commons. So we basically had to do as we were told. However, the legislation has been a bit of a problem, because there are some areas where there are clear city decisions being made. So as a result, we are looking at the moment at not repealing the Act itself, but amending it. But at the moment, because everybody's involved in one issue, which is Brexit, all other issues, domestic matters and everything else, have basically gone to one side. And you see that that's had actually a very damaging effect on Britain. Now let's go on to this or one side. Okay,
So we've got the next one. Just